Good morning, everyone. Happy sunny Monday. What better way to start a sunny week though than listening to Adam from Mercy Law. So thank you, Adam, for being here in the sunshine. So we've quite a few attendees registered this morning. Um, I see the numbers are popping up there as we go. So if it's your first Simon Talks, welcome. You feel free to share about Adam and Simon Talks on social media if you want to use the hashtag Simon Talks. We've a good few in there now, so I am going to be quiet. I'm going to hand over to Adam now for probably a half an hour-ish or so,
Mhm.
maybe 40 minutes because he's lots to get through. And then Adam will stop sharing, we'll come out, I'll pop back on the screen and we'll go through the Q&A. Just want to say, I know everyone is always busy. Um, Adam has been on my wish list for a while for Simon Talks, and I know he's so busy, but the work they're doing in Mercy Law is incredibly important, which is why I wanted him to come and share a bit of his brain with us all this morning. So I'm going to be quiet now and hand over to yourself, Adam. I'll be in the background if you need anything. So I'll see you on the other side.
Perfect. Thanks a million, Bear, and thanks everyone for attending. And I'm sure everyone's nicely sunburned after a good weekend. So what we're going to do, I'm going to start sharing some slides here for you. And what we're talking about today is some of the common issues that we would encounter for both social housing and homeless services. So challenges that people have in accessing some of these services. So just by way of introduction, my name is Adam Boyle. I'm one of the solicitors from Mercy Law Resource Centre. We are an independent law centre and a registered charity. So what this means is that we essentially are operating as a law firm, but at the same time, in addition to providing legal advice and representation, we engage in policy work, and we also provide training. The main areas of our work are working for people who have trouble accessing emergency accommodation or social housing supports or challenges related to that. You can see on the screen there, the purpose is to protect and vindicate the rights of people who are homeless or at risk of homelessness. And we provide free legal advice on social housing and homelessness issues. We do also provide legal representation and can act for clients, for example, before the High Court. We provide legal support and training to organizations and professionals working in this area. And then we also work, including, for example, through the Irish Homeless Policy Group, on which we sit with there, and the Islamic Communities of Ireland, to advocate for changes in law. And the ethos, of course, is to treat all of our clients with respect and compassion. So, the aim today is to have a little bit of a chat about social housing supports and homelessness supports. And we're going to look at, rather than kind of going into the start to finish of how to apply and so on, we're going to look at three common areas that we see as an issue. So, as a model, what we do is that we would take cases directly from people who approach us, or more commonly, services such as the Simon Communities may be working with a client who's having difficulties, and they will then make a referral into us. And so these are issues that we're seeing that are recurring, but which are not necessarily in compliance with the legal system that exists therein. So I suppose the thing to start on and just to talk about that runs through social housing supports and homelessness supports is to know that these are governed by law. They're not just governed by the primary statute, the Housing Act, for example. In many cases, there are a series of secondary sources of legislation, so the likes of statutory instruments, regulations that are made under that by the minister. From there, below that again, there tends to be guidances from the Department of Housing or the housing agency, who are the bodies who have responsibility under statute to share that guidance. Separate to everything to do with housing, these are also public bodies making decisions which impact on the rights of people who are trying to access these services. And so, what that means is that there's this entire body of human rights law, constitutional law, administrative law that actually has to govern the actions of local authorities through this, whether it's written into the statute or not. So, these are things like your right to fair procedures, your right to be heard before a decision is made that impacts on you, the responsibility of a administrative decision maker to make decisions in a manner that are reasonable and are proportionate and reflect the rights at play here. So in the same way that the kind of rules that would apply, for example, if you were applying for planning permission, a local authority wouldn't be allowed to say, we're not giving you planning permission just cause, or because we have our own rules, or so on. Those same rules would apply for access to social housing and homeless services. And it's the same rules that bind in a similar way, for example, when a person is applying for international protection, or to a lesser extent, the different engagements that you can have with the state and the responsibilities that state parties have. So we're going to start by looking first at two common issues that we see come up for people trying to access social housing supports. And then we're going to have a look at one of the kind of broader challenges we're seeing with people trying to access homeless services. I think what should become clear, if it isn't clear already, is that these are, and it's important to say, governed by two entirely separate legislative regimes. The primary piece of legislation governing access to social housing supports is the Housing Miscellaneous Provisions Act 2009, with a series of regulations made under it. Now, unfortunately, it does also draw from some older legislation as well. Whereas, and you'll see it later on in the presentation, when it comes to access to homeless services and homeless supports, that is governed entirely by the Housing Act 1988. So I think that's an important kind of two things to bear in mind as we go into this, is that number one, this is an area that is governed by law and you have fair procedures rights and everything underneath it. And number two, housing and homelessness. Those two things are separate within the legislation. So here we have the different types of social housing supports that you can be provided with. We can see here, these are probably common enough to all of you. You can see the idea of direct social housing support by the local authority being, for example, a council house or a site, wherein your landlord is the local authority. Your rent is paid directly to the local authority. It's a differential rent based on the rules for that local authority, and that needs to be publicly available. The Residential Tenancies Acts do not apply because your tenancy instead is governed by the Housing Acts directly. Alternatively, you could have approved housing body accommodation. So this would operate very similar to council provided accommodation in that you will wait until you get to the top of the list and you will be allocated a property. But instead of the property being owned by the local authority, it will be owned by an approved housing body. So I'm sure you've heard of plenty of these, the likes of Respond, to Sophia Housing, this kind of thing. And what they would do is they essentially don't have control over who goes in. The local authority sends the tenants in, and the local authority pays rent to the approved housing body, typically a long-term agreement about 80 to 90% of market value. Whereas as the tenant, you yourself are paying your differential rent to the local authority themselves, and your tenancy is governed by the Residential Tenancies Act in a similar way to how your rent or your residential tenancy rights would be covered if you were renting privately. And then finally, the most kind of common one for people who are on the social housing waiting list is to access the housing assistance payment. In that situation, of course, your landlord is a private landlord. The local authority is, we say it's supposed to pay the full amount up to, as we know, there are top-up limits by which the local authority can only pay so much of the rent. It is quite common now, unfortunately, with rents getting higher, that a tenant themselves would pay a top up on top of what the local authority pays. And in addition, then you would pay a contribution towards the local authority. And again, the Residential Tenancies Act apply there. So circling back to what we talked about at the top, the important thing to remember is that with social housing, this is governed by law. And so the primary piece of legislation is the Housing Miscellaneous Provisions Act 2009. You may have also heard about the 2014 Act, but that primarily actually amended the 2009 Act. If anyone is looking up this legislation, I always recommend that rather than using the Irish Statute Book website, that you would instead look for what's referred to as the consolidation, which is held up by the Law Reform Commission. So this 2009 Act has been changed in various places, but the Law Reform Commission puts up a version of the Act as it is today, which is really, really helpful for understanding. To a smaller extent, there are other acts that are at play, the 1997 Act, the 1966 Act, they have a role, but really the main piece of legislation at play here is the 2009 Act. Underneath that primary legislation, the Minister for Housing was empowered to make regulations. And there's a few different regulations made under that act, but the main ones that you should be familiar with are the Social Housing Assessment Regulations 2011 and the Social Housing Allocation Regulations 2011. Now, each of these have been amended slightly as well, but they're largely kind of as they were. I suppose the thing to remember is assessment occurs as you apply for social housing, allocation occurs as you get to the top of the social housing list. So the idea of these is to kind of operationalize how things are supposed to work. The Act lays down the broad rules. This starts getting into how areas of choice work, for example, and how social housing assessment is supposed to be carried out, etc. Under that, again, we have local authority allocation schemes. So these are a requirement. Every local authority in the country has to have one pursuant to the 2009 Act. And those allocation schemes have to be publicly available both on their website and in person from the local authority. If you work in an area regularly and you don't have a copy of it, I suggest that you get it right away. They vary in length. Some of them are very short, some of them are longer. But what they do is they're supposed to govern how the local authority is going to allocate houses, how they're going to operationalize their transfers, how they're going to have priority on their lists, and so on, how they're going to deal with succession of tenancies. So I would definitely recommend that you familiarize yourself with allocation schemes because they'll be very relevant. And then again, under this again, we have guidance and circulars. So that's kind of where perhaps there is a little bit of a lack of clarity around the primary legislation or the secondary legislation. And this guidance is sent out by the Department of Housing. So just to be familiar with that kind of pyramid of the legislation. And again, as I said, being clear that this is governed by law. So when you apply for social housing, at a high level, really what you need to be able to do is you need to be able to show that you are both eligible and in need of social housing supports. You submit your application form to the local authority. And as can be said here, you can't apply to multiple local authorities, but you can specify up to 3 areas of preference or choice within one local authority, or in some cases, there are these kind of situations wherein you can, for example, if you're in Dublin, you could have an area of choice in Dublin City and also an area of choice in any of the neighbouring Dublin councils. I think it's important to note as well, this case here, H and South Dublin County Council, it made clear that you can't apply to multiple local authorities at once, but there is no reason why if you were on a local authority list and then you decided to come off that list and apply somewhere else, you are entitled to do that within the remit of the law. So it's an important case, and it'll be quite important later on as well for understanding some of the timelines involved. So just here on the right-hand side on this slide, you'll be able to see this is actually an extract from the Dublin City Council social housing application form. I think the thing to be really clear about is that this application form is a statutory document. Back when the 2009 Act first came out, there was instructions to local authorities on how to have their forms. And then bit by bit, we've gotten to the point wherein all of the forms across the country are the exact same, except for the areas of choice, which obviously will vary between local authorities. And that's important to note because it does show that there is supposed to be a level of kind of similarity across different local authority areas. So the first common issue that we see an awful lot is a lack of clarity around how many documents are needed or how long a local authority has to make a decision. This is primarily governed by the Social Housing Assessment Regulations 2011. It's important to note that these include clarity on, for example, the social housing application form, which, as I said, is a statutory document, therefore the amount of documents that you might need to apply for social housing, but it also governs how the local authority makes their decision and how much time they have to make a decision. So what we can see here is this is the checklist that you may be familiar with. And if you're assisting a client in making a social housing application, I recommend being very familiar with this checklist and making sure that you are absolutely clear. Because it should be the case that when you have properly completed the social housing application form and you have the required documents on this checklist, which again is the statutory checklist, you should have a properly completed social housing application. And what that does is if you submit a properly completed social housing application, then the law clicks into place and you start a timer for the local authority to make a decision. So you have a properly completed social housing application form. you have the relevant supporting documentation. Now, the local authority, from the time that they have received that, they have 12 weeks to make a decision. That is assuming that it is correct and properly completed. So one of the issues that we see an awful lot is correct and properly completed application forms, for example, being handed back and being told, oh, well, actually, we have a local requirement that you need this document or that document or so on. If they're not on the checklist, it's hard to see how that would actually be a legal requirement. What the local authority are entitled to do under the 2011 regulations is to seek verifying information. So, for example, maybe you're applying for social housing support in somewhere on the basis of your local connection, and you have provided, a letter from your child's school confirming that they are in school in that area, which would be a local connection, and you have put in a properly completed social housing application form. They might be able to come back and say, okay, look, we actually need to verify that your child is still in school because this letter was from 6 months ago. For example, they might do that. But what's important to note is that during that 12 weeks, the local authority, based on the regulations, is entitled to come and ask for verifying information in writing. And when they do so, you have 4 weeks to respond with that verifying information. And as soon as you have done so, the local authority has 6 more weeks to render a decision. Now, the reason I have that there, the apple, there is one bite of the apple. The regulations do not envisage that a local authority can come back over and over again and continue to get 6 more weeks continually. The decision in H and C, Dublin County Council, made clear, and it was a case wherein a person had applied for social housing supports, they'd been asked a little bit, and then the council essentially went quiet. And they then tried to reapply a year and a half later. There was a lot of confusion and rejection, and a case was brought. And part of the argument that was made was that the local authority was already still considering their application from a year and a half ago instead of the fresh application. And the court made clear that when you have a properly completed social housing application form that has gone in, the local authority must make a decision. They don't have to make a decision to approve you, but if they're not going to approve you, they need to make clear the reasons why they have not. But they can't just perpetually kind of leave you on the long finger, assuming that your application is complete. So that's why I'm saying that checklist at the start is really your best friend here. We can circle back to that if needed, but the now common issue number 2 is about what local authority we should apply to. So again, this is actually governed by law. It is Regulation 5 of the Social Housing Assessment Regulations 2011. And I will make it clear that that regulation was amended in 2016, and it's in a very important way. The idea behind Regulation 5 is really to empower a client to consider where they might want to go. So I always use my own example that I live in Dublin City, and therefore, if I wanted to, I could apply under Regulation 5A because that's where I normally reside. But maybe I actually want to be closer to my parents, even though I live in Dublin. So my parents are living in Meath. Maybe I would instead apply and say, look, I don't live in Meath, but I have a local connection in the form of a relative who has lived here for at least 2 years. Therefore, I want to apply in Meath. Maybe I want to be closer to where I grew up. And I say, actually, look, I live in Dublin. I don't have any relatives in Fingal, but I used to live there for 5 years. Here's my proof of that. I want to apply in Fingal. Maybe I want to apply to be closer to my office and it's in South Dublin. So maybe I apply there and I say, well, look, here's my employment contract. Here's a letter from my employer. And that shows that I have a local connection there. Maybe in some circumstances, I'm living in one place. I don't have a provable local connection to somewhere else, but I don't want to stay here for one reason or another. There is also a power on every local authority under Regulation 5C, which gives them a discretion to accept a social housing application, even if I neither normally reside there nor have a local connection there. And this is wherein, we're looking at secondary legislation, but remember then the step down from that, there's guidance as well. So one piece of guidance that is relevant for that discretion point is there is very clear guidance from the Department of Housing in the form of their 2017 domestic violence guidance, or their 2025 direct provision guidance. You might be someone who has experienced domestic violence in the place that you lived, you have fled, and you are now trying to apply to somewhere that you don't have previous connections. But you are saying, look, the reason I'm going there is because I want to try and escape the domestic violence that was at home. And that is directed by the Department of Housing. That is when you should use your discretion, local authority. Similarly, you might be in direct provision and you might have been living in direct provision for the last 2, 3, 4 years, during which time every 6 months you were moved to a different county by IPAS. And now you've gotten to the point where they've said, yeah, actually, you have status. You're going to be able to live in Ireland for the rest of your life. And you say, okay, well, look, I'm currently in Donegal. I don't actually want to be in Donegal. I would rather be in Galway or Cork or Dublin. I want to go there to try and get work. And again, that is one wherein the department have said, look, these people have not chosen where they're living currently. They may not have a local connection somewhere else, and therefore your discretion is really important here. But the reason I have this up, and this should be fairly clear, the reason I have this up is that we're regularly seeing confusion or conflation by local authority housing officers on these exact points. So I mentioned that the 2016 amendment to this, it was an attempt to clarify, because what this regulation says is that you can apply to any one area, which would be either the area that you normally reside in, or the area with which you have a local connection. And then they amended to make it very clear when you do not currently live there. Now, I'm paraphrasing that. So the relevance of local connection for social housing supports that we constantly see kind of being used, that's only if you're applying somewhere other than where you live right now. And so we can see here on page 17 of the social housing application form, you can see there's 3 boxes. And so household is normally resident in the local authority area, or household has a local connection with the local authority area, or third option, the local authority should consider for the following reasons. So these boxes actually align with regulations 5A, 5B, and 5C. And so we do see ones where people are ticking, look, I'm normally resident, and then they're also ticking local connection, and they're saying, look, my kid's in school, and I've lived here for 5 years, and I've shown proof of that, etc. That is kind of a hat on a hat, and it's not required. And back in 2013, this guidance was circulated by the Department of Housing specifically on this point because the ombudsman had come to the department and indicated how this mistake was happening kind of consistently. And so what this makes clear is if you are applying on the basis that you normally reside there, not local connection, I live in Dublin, what this note says is if you can prove that you live there, there is no minimum period. The local authority aren't allowed to say you live there, but you have to have lived there for 2 years, 5 years, 6 months, anything like it. You live there. You can show you live there. Therefore, you do. You do not also need to prove a local connection. Not a requirement. It is spelled out in black and white in this 2013 guidance. The amendment in 2016 reflects that. On top of that, the elements of this guidance have been replicated in the domestic violence guidance in 2017 and in the IPAS leaver guidance in 2025. What it talks about is relevant documentation that can be shown to prove that you live in that area. And it explicitly says relevant documentation such as a utility bill, a proof of a social welfare payment to an address in that area, a lease, etc. And I think that etc. is really important because you may have somebody who maybe is renting a room and they don't have a formal lease and they don't have access to utility bills, and maybe they're still registered in their parents' house for their social welfare, but they've been living up here, they've been working, etc. I think it's really important that if someone is applying on the basis that they live there, you do your best to get as much evidence that you can as to where they're living. And as I said, there's a copy of this guidance on our website. It is from the Department of Housing. They had confirmed recently to us that it remains in place. In fact, they recirculated it earlier this year because we raised with them this issue with local authorities. So it may be something that you want to include a copy of this guidance when you're assisting someone in applying for social housing supports. The additional piece from this guidance that is really relevant is that it says if you're dealing with a household who are in emergency accommodation, production of social welfare payments received in that area might be the only proof available to the household. So one of the things that really annoys me is when they come across a case of a family who are in emergency accommodation in a local authority, and they get a letter saying, okay, we've actually done your assessment and we've decided that you don't have a strong enough local connection to our area and you need to go somewhere else. Now, if you were on the social housing list somewhere else, that's one thing. But if you are living in Dublin or Galway or Cork or whatever, and you're in emergency accommodation and you apply for social housing supports, you should be approved on the basis of normal residence. You are in emergency accommodation in that place. The only time that local connection comes in is if I'm living in Cork, but I want to move to Dublin and I have one of these criteria here to show that I have a local connection. It is when you are applying out of county. And so, look, this is all defined in Regulation 6 of the 2011 regulations. You can find them online, but I'm sure you're familiar with them. So, the way that you can show a local connection if you're applying somewhere out of county, a household member. So, not necessarily the lead person taking the application, it could be anybody in the household, has resided for a continuous 5 year period in that area, or one of the household members is working in that area or within 15 kilometers of that area, which can be really relevant if you're kind of working in the suburbs outside of a city, for example. A household member is in full-time education in that area. And then a household member with an enduring physical, sensory, mental health, or intellectual impairment is attending a medical or residential establishment in the area concerned that has facilities or services specifically related to such impairment. Now, that hasn't really been tested in court, but what I would suggest is that that probably doesn't count for a typical GP, but specialist medical treatment would be covered there. And then finally, you might be able to apply on the basis that a relative of a household member resides in the area concerned and has resided there for a minimum period of 2 years. The definition of relative is very, very broad. And I would recommend taking a look at it in the 2011 regulations. The second half of the list is an open list. It talks about, or for example, another relative, such as an aunt or an uncle or a cousin, with whom you have a relationship of commitment and dependence. So just to know that maybe if you are applying because you need to be close to your uncle who's getting older and your uncle raised you, you might want to put in a bit of a cover letter to explain, look, this isn't, I'm just trying to get close. Like, this is someone that I have a relationship with and I would like to be closer with them. So we're going to move on to the last bit now, which is homeless support. Um, it's very relevant to look at. This is the legislation that governs homeless services. So you remember when we were talking about social housing, we had the 2009 Act, we had the regulations, we had the allocation schemes, we had the guidances. This is it. Sections 2 and 10 of the Housing Act 1988 govern how homeless assessments are to be carried out and what happens when you assess someone to be homeless. That does, Section 10 empowers the minister to go and make regulations underneath it that can govern, for example, in a similar way to how the social housing assessment regulations have been done. To our knowledge, those have never been used. Those powers have never been used to make more regulations. There are some guidances that touch on this, but not specifically. So we have some guidances, for example, the domestic violence guidance talks about the need to provide emergency accommodation or carry out homeless assessments to people who are homeless and reminds the local authority of some elements of the law. But it's not like the social housing front, wherein there is this detailed kind of series of steps. There is just the legislation. And this is what the legislation says. Section 2 is the Irish law definition of a homeless person. This is it. A person shall be regarded. So it has to be regarded by a housing authority as being homeless for the purposes of this act if there is no accommodation available, which, in the opinion of the authority, he, together with any other person who normally resides with him or who might be reasonably be expected to reside with him, can reasonably occupy or remain in occupation of, or he is living in a hospital, county home, night shelter, or other such institution, and is so living because he has no accommodation of the kind referred to in paragraph A, and he is, in the opinion of the authority, unable to provide accommodation from his own resources. So breaking that down, There is a lot of discretion in that on the part of the local authority. So a lack of accommodation, it is incumbent on the applicant to show that they lack accommodation, which they could reasonably occupy or remain in occupation of. Just jumping back there again, we're seeing in the opinion of the authority. So the authority might disagree with them as to whether or not they're able to use that accommodation that is available to them or not. But again, we go all the way back to all of the underlying administrative law, constitutional law principles. The local authority needs to make decisions that are reasonable, that are based on the evidence before them, that are not based on external considerations. And then we have a lack of access to a lack of access to accommodation. So if you're living with another person or could reasonably be expected to live with another person who has access to alternative accommodation, you may not be homeless. And then a lack of resources. So this is an important piece as well. Unlike the social housing regulations, this is not if you are over this much income, therefore you cannot be homeless. Rather, it is a case by case assessment. It is a factual assessment. So common issue number 3, extra criteria being added to access homeless services. As I said, this definition in Section 2 of the Housing Act 1988 is the legal definition of homelessness. Once you get through that gate, the local authority has determined you are homeless, must record you as such, and then has discretion on how they're going to support you. But what we're seeing is that we're seeing extra legal criteria being added, criteria that we don't believe have a basis in legislation or government guidance. So, for example, I'm sure you've seen all over the place this idea that you need to have a local connection to the area in order to access homeless services. That is an attempt to use some of the language from the 2011 Social Housing Assessment Regulations and bring them across into the access to emergency accommodation legislation. But as I said, the minister has had power since 1988 to make regulations like that and has never done so. And therefore, you can't just decide as a public body or as a local authority, I'm going to make up my own rules here. I'm going to bring rules across. On top of that, as we said before, local connection for social housing supports is only relevant if you are applying for social housing supports out of county. So the idea that you could be living somewhere, be evicted from somewhere, try and access emergency accommodation, and be told to go somewhere else for emergency accommodation, actually, if anything, it cuts against the actual 2011 regulations, which have said, well, look, if you're in emergency accommodation, you are normally resident. You don't need to prove a local connection. It is not lawful. It does not have a basis in legislation or guidance. And if you are being told this by a local authority, I would be suggesting that you get it in writing. Another one that we see regularly is this requirement that you be approved for social housing supports. Again, social housing supports can take 12 weeks or more to make a decision on. It is not a requirement that you be approved for social housing before you access emergency accommodation. The minister has stood up in the Dáil before and said this. We have blogs up about this. The idea of access to emergency accommodation is to respond to an emergency. The idea of access to social housing supports is for your long-term housing needs. We see immigration status being raised as an issue. People who are lawfully resident in Ireland being told, well, you haven't lived here for 5 years, therefore you can't access homeless services, etc. That is an attempt to, again, bring in not even regulations, but guidance that exists only over social housing supports that has no basis in primary legislation and bringing it over into emergency accommodation. And again, the Department of Housing have indicated that that should not be the case. The Irish Human Rights and Equality Commission and the Ombudsman's Office have each said that that shouldn't be the case. A joint Oireachtas committee back in 2024 made clear that that shouldn't be the case. A person who is allowed to be in Ireland and becomes homeless should be able to access homeless services. Full stop, whether or not they are eligible for long-term social housing supports. And then this piece here, not recording reasons. There is a national system. It's the PASS system, Pathway Accommodation Support Service. If a local authority decides that someone is not homeless, they should be recording that on the PASS system. It is one of your administrative law rights to be provided with clear, written, and intelligible reasons to explain a decision by a public body that impacts on your rights. It's Connolly and An Bord Pleanála is the Supreme Court case if you need to cite it when you're talking to a local authority, but they know that they are obliged to give you written reasons. So if your client is refused access to emergency accommodation because they don't have a local connection, or they don't have an open social housing application, the local authority should write that down in a letter and give it to your client. In a lot of cases, we see that they don't. And I think that that can be quite telling if there are reasons being provided orally that are not matching what is being written down. I think that would raise questions for me. So finally, and we'll get to Q&A now. I'm sorry I've run over a little bit. What to do in these situations? So I just think, as I said, that the key takeaway, whatever about these three common issues, the key takeaway, there are background legal principles. The local authorities are acting in compliance, or supposed to act in compliance with their legal obligations, both under statute and secondary legislation, under guidance, but also under administrative law principles. So keep notes. That includes when you submit a social housing application, scan every document and keep a copy of it. Send it in by email and registered post if you can to the local authority. That way you have a date that it went in at, you have confirmation of every document that went in. And if they come back and say, well, actually, we can't complete the social housing application because it's missing this document, you can say, well, actually, no, that document wasn't closed. So I trust that you will continue to do so. If you have a meeting with someone from the council, make sure that we have their name and we have a little bit of a note of what they have said. If you email yourself after the meeting, you have a contemporaneous note. So if you get down the line and they say, well, that was never said, just be, well, I have an email at the time that says it was. If you are told that they cannot do something or they will not do something, ask them for reasons for that decision and ask them in writing if you can. They are obliged to provide clear written reasons for their decisions. Ask about appeals. About 2/3 of the local authorities in the country in their allocation schemes have a route of appeal, whether the staff themselves know it or not, for decisions related to social housing supports. So check the local allocation scheme, check the website on the council's website themselves. There are some local authorities that don't have any appeal systems written on their websites or in their allocation schemes, but which have indicated to the High Court that they have these. I recommend that you check that and that you try and appeal to a more senior decision maker. Consider the customer charter on the local authority's website. These customer charters detail that they're going to respond to emails or correspondence within a set time frame, that you'll be able to get a name and a number and so on. If you're not getting treated or your client isn't getting treated in compliance with the customer charter, you can move outside of the housing team and make a complaint to the customer service team and say, well, look, this is not happening in line with your own standards. Speak to an advocacy service. I mean, you guys are the advocacy service, of course, but more so for your clients. I mean, it's important to come to the likes of the Simon communities, the likes of Focus Ireland or Crosscare, those kind of services, who will be able to advocate and try and push. And then consider legal advice or other escalation. So you have a right to access records. You can submit a Section 12 Freedom of Information request and try and get the records related to your client, or you could make a subject access request under the GDPR. But also, and a perhaps underused piece, is that if a local authority refuses to provide you written reasons and says that they're not going to, no matter what you do, you can submit a Section 10 Freedom of Information request, wherein you write to them and you say, hello, I am Adam Boyle. Pursuant to Section 10 of the Freedom of Information Act, I would like to understand the reasons for your decision on the 5th of May to tell me that I'm not eligible for emergency accommodation. Please provide these by writing, and they must do so within 1 month. So look, that's the main bulk of it. I'm always happy to take questions. I'm looking forward to these now. And if you ever need to escalate matters or get a bit of a steer, Mercy Law are happy to take referrals as needed.
Thank you
Perfect.
so much, Adam. Every time I listen to you, I learn something new. And it's so important. And there's loads of questions coming in. So I'm going to be quiet and we'll try and go through some of them. I'm not sure if you might have kind of addressed some of them as we were going through. And just to say, we're so grateful for the incredible work that Mercy Law does. So we have a question here. Do foreign certs like marriage cert need to be translated for housing applications?
I'm not aware of any primary legislation with regard to that. There is, so I think a couple of things to be aware of is that there is very detailed guidance about persons who have left IPATH and the kind of documents that they require. So I would recommend you get a copy of that. It is publicly available. It's 2025 guidance, and I'm sure we'll be able to share it. What we see sometimes is people who have refugee status being told, okay, well, you need to go and get the original marriage cert from the country you fled, and that would be unlawful because you can't contact the country that you came from if you have fled from there. If you are just a migrant, it may be understandable that they would try and seek some level of kind of clarity around, your marital background and so on. It's not clearly defined. If it is requested, sometimes that can be extremely expensive. So, I mean, you could explore whether you can write a letter to confirm what's in there or anything like it. But I would be suggesting that if you're asked for something like that, you might ask, is there a policy basis or is there anything else that we can show? Because this is very expensive.
Yeah. And that's actually something that really struck me through particularly the piece about the homeless services of the amount of self-advocacy and kind of, I know knowledge is power and information is power, but yeah, it is unfortunate that people kind of have to have that level of energy with everything as well.
Mhm.
So Trudy has asked, does a newly homeless person, so a person newly experiencing homelessness, need to be registered first or assessed before they can access homeless services via the free phone in the Dublin area?
So that's actually a really interesting point. So what we know happens is that people will request a homeless assessment, and we know that in some local authorities, like rural local authorities, they might say, "Oh, well, we only do homeless assessments on Mondays and Thursdays, for example. So don't become homeless outside of those days."
Yeah.
In Dublin, we have almost the opposite problem in that they carry out homeless assessments daily, but you might be waiting several weeks to be able to access a homeless assessment. So until the homeless assessment is carried out, the local authority cannot decide whether or not you're homeless under Section 2 of the Housing Act 1988. But as an advocate, one of the things that you can do is that you can make a request for access to emergency accommodation on someone else's behalf, or the person can make the request themselves. And I suggest that if you're doing that, you put that in writing and you say, I am making this request under Section 10, subsection 2 of the Housing Act 1988. And on top of that, you may say, we understand that it will take you some time to carry out a homeless assessment, but we would ask that you use your powers to provide this person with emergency accommodation in the interim, and we would ask that the power that you use is Section 10, subsection 10 of the 1988 Act. So the distinction between those two things is Section 10.2 is a request formally for emergency accommodation. The courts have made clear that that does devolve the responsibility on the local authority to respond to that request. But then on top of that, Section 10.10 empowers the local authority to provide services to somebody while they're still making inquiries, essentially to determine if they're homeless. So particularly if you have somebody who's out in the street and they're going, look, we'll see you in 3 weeks for a homeless assessment, being
Yeah.
able to say, this is a formal request, you have the power to do so. This person is out in the streets and they're at risk. So please use that power. And if you're not
Mm.
going to use that power, tell me why in writing.
Okay. That's really good to know. I'm taking notes as well. Um, Shannon has asked, is the local authority's decision based solely on meeting the requirements, i.e., once earning under the specified salary, no other income, links to the area, and currently without stable housing?
Yeah, so there are two different decisions, obviously. So the social housing front, you need to show need and eligibility. So need tends to be, are you under the income threshold? And those vary depending on the local authority area and the size of the family. Do you have alternative accommodation? And what that means is, do you have somewhere you could stay, or do you have somewhere that you could sell and use the proceeds to house yourself? There are some really interesting cases around that. So, I mean, for example, a family who previously used to own a property in Poland and they had given it to their son 10 years prior, and they applied for social housing and they were rejected. And they basically successfully made the argument that, well, look, we don't have the property anymore. And even if we did, it was only worth, I think it was 12K, which is not enough to secure our housing. So, you're looking at that in terms of need. Do you have somewhere else to stay? Do you have income? And then you get into eligibility. And so eligibility is stuff like, that regulation 5 that we were talking about. Is this the right local authority for you to apply to? Eligibility looks at immigration status under Circular 41 2012. But again, that's just guidance. So, you couldn't necessarily hop off a plane from a non-EU country and walk in and say, I want to get onto the housing list right away. Um, and kind of then you've got the criteria around that. So if they are making a decision outside of those areas, outside of those rules, it's really incumbent on them to be telling you what law they're applying or what policy they're
Mm,
applying, because it's quite clear as to what they're supposed to apply.
mm.
And then, sorry, with regard to homeless services, the decision is made on the basis of Section 2. Do you have somewhere else to stay? Do you have means? That's it. You are either homeless or you're not. There is then broad discretion under Section 10 as to how they're going to support somebody. And so it
Mm.
is open to a local authority to say, we're not going to support this family. But it's very hard to see how they could use that discretion and know, like, have made the assessment that someone is homeless and we're going to leave them sleeping rough in a manner that is compliant with their broader human rights duties as well. So I think what we often see is the kind of, unfortunately, local authorities almost falling at the first hurdle in that they're saying, well, we've decided you're not homeless because X, Y, and Z. And that's actually not relevant for the Section 2 assessment. You either, do you have somewhere to stay? Do you have means? That's the test.
Yeah. Does the definition of homelessness include people under notice of termination?
So that is a question. And look,
It,
that's down to the fact that the 1988 Act is quite old and hasn't been updated. So it's do you have alternative accommodation that you can be reasonably expected to occupy or continue to occupy is the assessment. So if you have a notice of termination that's running out in a year and a half, I
mm,
could see a local authority saying, look, come back in a while. If you have a notice of termination that's running out next week and you've got a large family and they're saying, well, we can't do anything, our hands are tied until next week, I would probably be saying there is sufficient kind of breadth in the legislation there for them to determine that you are homeless or at least at a risk of homelessness and start putting a plan in place. Even if they're not going to take you out of an apartment that you can still stay in for the next week and put you in emergency accommodation, this idea that you need to turn up on the day of your termination date, I don't think that that necessarily is compliant.
yeah, because I know there's a whole thing as well with HAP and homeless HAP and the discretionary hire limits as well. And, even if you
Hmm.
have a couple of months' notice and you're trying to do that preventative piece, that in
Yeah.
some local authorities, you are kind of told to wait until closer to the date, which seems to go against all kind of common sense.
Yeah, I mean, like the idea of homeless HAP is it's one of the few bits where the kind of social housing and homelessness legislation crosses over. And so that idea is if a household are homeless or at risk of homelessness, the local authority has discretion to give an uplift. And homeless HAP is quite funny in that in the Dublin region there is a statutory legislative homeless HAP that allows you to increase by 50%. Outside of that, you can increase by 35%, but it's not statutory. It's all just guidance. But it's there and it's available. So if you have a notice to quit and you're struggling to find somewhere else to rent, and the local authority are saying, well, there's nothing we can do, our hands are tied, that might be one wherein you're submitting a Section 10 Freedom of Information request and saying, on the 25th of May, we made this request to you. You said no, you didn't give us written reasons. Please, pursuant to Section 10 of the Freedom of Information Act, give us those reasons. Give us the
Mm,
underlying findings of fact. Give me the policy that you
mm,
are relying on. And sometimes that might be enough. You might submit a freedom of information request and get a call 20 minutes later to say, look, would you pull that and we'll look after it? Okay. Sometimes
yeah.
that happens as well. It can
Yeah.
be a useful tool.
I think I know the answer to the next one. Orla said, if a client is in custody and will need to avail of emergency accommodation upon release, is it
Mhm.
correct for the council to say that a housing application must be submitted, even if not fully complete, to avail of it? So to avail of emergency accommodation.
No, but it is somewhat understandable that they want to try and see a way to that the person can get out of emergency accommodation in the longer run. There is a very useful circular on this that I will provide to bear, and we might circulate on it. So there was an agreement between all the local authorities, the Department of Housing, and I think the probation service around this issue specifically. So I think the thing to note is number one, you can be in prison and have an open social housing application. You can be in prison and you can apply for and be approved for social housing supports. In fact, it is encouraged to try and reduce the likelihood that you exit prison straight into homelessness. And so it's understandable that a local authority might be saying, look, don't just contact us to try and get emergency accommodation, contact us to try and get a long-term pathway out of this. We might be able to set up a HAP place finder, for example. But if the local authority, sometimes the alternative is the local authority are trying to figure out whether or not you fall into that regulation 5A, 5B, local connection, normal residence piece before they make a decision on your homeless services. And that one, I think, is a little bit worse, wherein you can kind of see things where it's like, well, you're in prison, you're not working, you don't live here anymore, we're not going to help you out. that's not really acceptable. Like, if you have a local connection, you can apply for social housing supports. And also, as we said, you can access social housing supports where you're in emergency accommodation because
Mm.
you're now normally resident. So look, I mean, it's understandable. We'll circulate the circular, and hopefully that'll be helpful. I know that TUSU do some great work on this, who are doing the resettlement of people who are leaving prison, and they're a very vulnerable cohort,
Mm.
and so it's really, really important work. So I would recommend linking in with themselves as well. They're really, really good.
And I suppose the thing about a social housing application is if you're starting it, you're going to be on the social housing list for years,
Exactly.
for years and years. Um, so Shannon is asking, this is really interesting. If a client is on the pass system, but they're
Mhm.
no longer deemed homeless after a period of time that they haven't been booked into emergency accommodation, should the local authority be putting up a public note on their profile to state that?
Um, so like the operational kind of side of Pass isn't something that I can really comment on. I don't have access to Pass except when I take it by freedom of information request and then exhibit it in court. But no, look, I mean, I think the question there, I'm not fully sure. If, for example, you're booked into emergency accommodation and you don't use that emergency accommodation for quite a while, for example, which I think might be what she's saying there, then the local authority would be entitled to say, and understandably, look, we're not sure that you're homeless. Like, we think you might be staying somewhere else. And so therefore we're going to pull the emergency accommodation. But yeah, they certainly should be, at a minimum, writing to you and confirming that because you need to know why decisions have been made. One would hope that that is also put on pass so you can see it.
Mm,
So it kind of does come back down to your right to understand why a decision was made. But it's not like the courts haven't gotten fully into whether or not that has to be in the form of pass or not. You just have to know
mm,
why the decision has been made. Now, alternatively, I'm not sure, maybe I misunderstood the question. If there is a decision that we're only going to provide you with emergency accommodation for a short period of time, there is scope within Section 10 for a local authority to set a deadline that you're only allowed emergency accommodation for this long. But again, we then start getting into the underlying human rights factors. We're in a housing crisis. It is
mm,
understandable that a person might be in emergency accommodation for longer in 2026 than they might have been in 2000, for example. And for a local authority to make a determination of, look, you've got 2 weeks, and if you haven't found something, you're out, that would, I think, be hard to justify in light of their broader human rights and administrative law responsibilities. And very much so, if that was something they were trying to do, they'd want to be crossing the T's and dotting the I's and saying, well, look, we put this on pass, we notified you, we did this, we put you in contact with these people, and you haven't done da da da. So if they're trying to do something without writing it down, without providing reasons, that's probably moving into the territory where it's not all that compliant with the
good
human
question.
rights responsibilities.
Yeah. Um, so many interesting questions. So this one is about a person with a domestic violence conviction. So
Hmm.
regarding the local authority's discretion to accept social housing applications with no local connection when considering domestic violence issues, does this also apply to those with a conviction? I regularly engage with individuals who have DV convictions leaving custody and have been told by local authorities that they cannot accept them for social housing or emergency accommodation supports due to a lack of local connection. Oftentimes, these individuals are unable to return to their own local authority due to their offence and for the well-being of the victim. So I've had situations where Gardaí have advised that the individual does not return to their local area, but then another local authority area is not accepting this. I haven't actually heard that before, but obviously, yeah, it must come up.
Mm. Yeah, I mean, look, the domestic violence guidance is focused on victim survivors for sure.
Mm,
What I would be thinking there more relevant is probably the circular that I mentioned for persons who are in or leaving custody. Um, and again, a local authority, you get out of custody and you go to the local authority and you try and access homeless services. They're not allowed to say you can't get homeless services because you don't have a local connection. That's not what the law says. The law
mm,
says you determine whether or not they're homeless and then you have discretion on how you're going to assist them. So they may not be complying with the law in the first place when they have done that. And the 2011 regulations and the 2013 guidance says if you're in emergency accommodation, you are determined to be normally resident and you can apply for social housing supports. So we do see some local authorities saying, well, look, I can't be expected to put this person in homeless accommodation because then I wouldn't be able to approve them for social housing support and they'll be trapped there. Has no truck with me because I think it's a misunderstanding and perhaps a purposeful at times misunderstanding of the regulations. If you're in emergency accommodation, you're normally resident. You don't need to have lived there for 5 years or be in school there or whatever. Plus, there is, that broad discretion under Regulation 5C. So I think, if you're applying, show that you're normally residing in the area. If you have a social welfare payment to an address in the area, maybe you're staying with a friend or so on, that is normal residence. Slash, go in and try and get your homeless assessment. And if they tell you to go somewhere else, be like, give it to me in writing, explain to me, put it on
Mm,
task, give it to me in writing, tell me why. And you can potentially dispute that. And then also in your social housing application, you may want to disclose. You look, I used to live there. I don't have a local connection to other places. I was imprisoned because of that. And even taking it out of the domestic violence context, you do sometimes have people who maybe were involved in criminality, they've gone into jail and they're going, I don't want to go back to the
yeah,
place wherein I was. And so, trying to advocate around that is really important as well.
yeah. Same with addiction as well, like that. If
Absolutely.
yeah, yeah. And actually, speaking of addiction, is it legal for a county council to avoid providing homeless accommodation to a client for a certain amount of time due to a history of addiction until they decide that the person has been sober for a certain amount of time?
I have, oof.
Yeah.
Addiction is recognized as a disability under the Equal Status Act. So suggesting that you simply won't provide any services to somebody with a disability might be discriminatory. It might, in fact, be
Mm,
direct discrimination. I have never heard of a policy from the Housing Agency or the Department of Housing that permits that. Um, as I said, they have very broad discretion, but they have to use their discretion in line with their administrative law and human rights responsibilities. And trying to treat a person with an addiction inherently differently than other people, like I struggle to see how they'd be able to do that lawfully.
mm,
Now, one of the challenges that we do see is that people who have exited active addiction might be offered a form of emergency accommodation that they feel they can't take because
yeah.
it brings them back into that kind of orbit. And that can be very challenging because that's now kind of a question of, well, look, is it indirect discrimination to not make a reasonable accommodation for this person's medical need? In the
Mm,
same way as like it would be potentially indirect or direct discrimination if someone was a wheelchair user and you said, well, the only emergency accommodation we have is up a flight of stairs. That's a little bit more gray, but no, certainly being like we just don't assist people who are in addiction. Like I would struggle to see how that
mm,
would be compliant, and
mm.
certainly, I mean, yeah, if you need to make a referral to Mercy Law, please do.
Please do. Yeah. Um, Alana is asking, we're told that someone has to have worked in Ireland to access emergency accommodations so that they are an EU migrant worker. Is this
Mm.
the case?
So this is an attempt to introduce a habitual residency criteria and kind of a mistaken conflation with EU migration status. So the freedom of movement for EU nationals is a little bit complicated. Primarily, it is for workers and dependents of workers. Um, so there is a degree that, like, you wouldn't necessarily, if you got off the plane and went straight into the council and said, I want to access homeless services, and they said no, you wouldn't necessarily, you might have a case there about the fact that they're leaving you sleeping rough or anything, but you wouldn't necessarily be able to bring them to Luxembourg and argue that they have interfered with your EU migrant rights. However, if you are an EU worker and you're refused access, that would, on the basis that you are not. For example, we always hear, oh, you're working, but you haven't been working for 52 weeks. Absolutely not. Once you're a worker, you've gotten through that gateway. There are additional complicating factors. Perhaps you are the spouse or former spouse of a worker who has departed the jurisdiction. You would still, under the Texera decision, if you are the primary caregiver to a child who's in school, for example, you would be entitled that way. It's really not as straightforward as some local authorities make it seem. But I think the important piece to note is that there is nothing stopping them providing emergency accommodation.
Mm,
They are able to provide emergency accommodation. There's no legal impediment to them doing so. It's actually a question of, in their refusal, are they simply being a bit harsh or are they potentially breaching EU law? And so certainly, yeah, this idea of, if you are in work, but you haven't been here long enough, you haven't worked long enough, it's very hard to see how that would be compliant with
mm.
EU law.
Are you okay for a couple more minutes,
Absolutely,
Adam?
yeah,
Yeah,
yeah.
there's
As
just
long as people
three.
don't mind listening to me more.
No, there, and I've never had these many questions on assignment talk, so it just shows. I'm going to come to Kelly next, which is Kelly works in a domestic violence service. A family has recently moved from Wexford to Dublin to a
Mhm.
refuge. They are being referred back to Wexford for emergency accommodation and won't be offered emergency accommodation in Dublin.
The policy and procedural guidance for victim survivors of domestic violence would lean against that. Look, I don't want to get into details of a specific case, obviously, but you need to look at like the assessment needs to be carried out when requested. So you can make a request under Section 10.2 and say we need emergency accommodation for this family. I would suggest getting a copy of that guidance. If they don't want to go back to Wexford, I think it's important to, or to whichever local authority, I think it's important to make clear why. Um, and make, sorry, not make clear why, but make that clear to the local authority themselves. Um, no, like, I mean, I don't see a legal impediment to them getting access to at least emergency accommodation. It's a case by case kind of thing. Like, I mean, if their names are on a tenancy or anything like that, but there is, there's sufficient latitude and scope for local authorities to make these decisions. And a household who are in a domestic violence refuge is a form of emergency accommodation. Therefore, you are normally resident in the local authority area. When you're residing there, you can apply for social housing supports pursuant to Regulation 5A, normal residence, this idea of local connection. Nah,
Mm,
you theoretically you could have experienced violence in Galway and moved to Roscommon and apply to Dublin, even though you don't have a connection, and say, I'm applying on the basis of 5C discretion and the 2017 guidance. They could have a bit more scope to refuse you there, but they're encouraged not to. But if you're living in Roscommon for even a few days and you're now that's your where you're living currently, you can apply
mm.
on the basis of 5A, and the guidance is really, really clear about that. So I would suggest getting a copy of that 2017 guidance ASAP, and kind of applying it to the facts. And I mean, put it in writing to them. Get it a
Yeah.
written decision from them as well. Appeal it. DCC has an appeal structure in their allocation scheme.
Mm.
Consider that.
That's a big takeaway from today as well, is that thing of asking for things in writing and putting things in writing. And
Hmm.
I would imagine that it's politely as well, like as you said, using the legal references and the references to the regulations. Um,
Hmm. Oh, but even sorry, even more simple than that. Like they're like, you and I have a meeting and you say, look, I can't help your client because he doesn't have a local connection, da da da. Sending an email to you 5 minutes later going, hi Bear, it was nice to meet with you today. I understand that you said this. I'm going back to my client to talk about that. Because it now, like, if you have been told something that they're not putting in writing, you now put it back on them to have to say, well, that's not what was said, for example.
mm,
And if that is what was said, maybe you took them up wrong, and that's a
yeah,
great opportunity to clarify it. But if it is something that it gets escalated and you need to get lawyers involved down the line or something, and they say, no, 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 the reason we made the decision was actually X, Y, and Z, just be like, well, why didn't you clarify that when Bear wrote to you 2 months ago and said this,
yeah,
So
yeah.
having those kind of written records, contemporaneous records, really, really helps.
Okay. If a client is under a deportation order or has
Mm.
no status because they've been refused or they've had unsuccessful appeals, is there an obligation to offer homeless assessment and emergency accommodation?
That's a little bit more unclear.
Yeah.
So, like, you know, the local authority has a responsibility to behave in a manner that is reasonable and to not unduly interfere. Like they have a public sector duty to respect human rights, and non-discrimination. But it is one that I would be very surprised that if a case was taken, you went to the High Court and you said, well, actually, this person is entitled to X, Y, and Z. I would be surprised on that. But it is a kind of a factual scenario. Like I've had kind of situations wherein maybe a person was undocumented and they were going through the process of documenting themselves, and it was tied to an unhealthy home environment or an abusive home environment. That brings it a little bit closer into kind of something that is something that would be arguable. But no, I think that would be a very difficult argument to make, a
Mm,
responsibility
mm,
of the local authority. Maybe they have highly vulnerable children and they're waiting for their deportation. That might be a little bit different. It's
mm,
fact specific.
okay. And this one, again. Really interesting. And thanks so much to everyone for all of the questions. So, if a local authority is refusing to take a client onto their housing list due to a court order barring them from the county for 3 years on release, what can be done?
A bar from the local authority area. I have not come across that. That is a difficult situation. Look, I mean, there's probably a little bit of a, if they're going to make that decision, they need to provide it to you in writing. I don't believe that there is, like, if you have a local connection, if you're applying because I used to live there for 5 years, I want to live there again in 3 years when I, can again, etc. You know, I wouldn't see them being able to refuse on regulation five, but maybe they can refuse on something else. Um, but um, sorry, apologies to call it. But I would be encouraging them to get that in writing. But then separately as well, like maybe it is a situation that you need to consider. Like, look, I'm living in Roscommon now, and I need to access HAP. Maybe I apply in Roscommon and I can use intercounty HAP if I want to move back to Dublin. It does mean that the end result is that you won't be allocated a house in Dublin, but you may be able to live there using HAP intercounty.
Mm.
There's a few options around it, but yeah, very much so. If they're determine that they want to live somewhere in particular, get it in writing, get the decision in writing. There is an obligation on the local authority to do so. They need to provide sufficient written reasons. There was a case called Zabiello, wherein a local authority had refused access to the housing list and issued a two-line letter that explained why they were refusing access, and the High Court referred to it as a terse and uninformative statement and struck down that decision for that and other reasons. Like there needs to be some clarity on the local authority having engaged with the facts, having considered the facts, and having applied them to the circumstances in question,
Mm.
and applied the law to the circumstances in question.
Um, there's a couple of other questions coming in there, but I'm going to have to wrap it up because we were supposed to finish up at 11. But I am going to say that there is a mercy law training happening, I think in July. Got an email
Yeah,
about it
there's
the other day. So I would encourage people with all of these questions to sign up for a mercy law updates and newsletters and like that. There's like I think it's a half day or a day train because I know I'm off
it's a
that
two and a
day.
half hour fundamentals of housing law training. I think it's the 1st of July, but don't quote me on that. It's
That's
on our
yeah,
social media.
yeah. I'm
And so that'll be delivered by one of my colleagues. It's a much more intensive and it walks through all of the kind of elements of it. Really, really helpful. I recommend it. In addition, if there's any kind of like regional groups and you have more than, for example, 10 people who want training, it may be something that contacting us directly, we might be able to do a specific training or a bespoke training. We can do trainings very specific if you have a team working in domestic violence or you have a team working specifically with migrants. Maybe we can do a special training on that. So please do feel free to reach out. And if you want to sign up to our mailing list, you can contact events@mercylaw.ie. If you have a case that you want to try and refer in, you can send it to info@mercylaw.ie. We triage our cases weekly, so it may be that we come back to you and we say, look, we need you to take these steps and then go, or we might say this isn't something we can do, or we might say that's great, it's going to be assigned to a solicitor. So please do feel free. I would encourage you to, if you're going to do so, make sure that you've taken the steps you can, submitted FOIs, had a read of our website, engage with the local authority, and then make the referral in, like having taken as much as you can. But yeah,
Thank you so much. It's been, and there was thanks were coming in on that as well, and people saying it's literally an eye-opening experience and everything this morning. So huge thank you, Adam. Really, really, really appreciate it. And I will talk to you soon.
brilliant. Thanks a million, folks.
Thanks, everyone. Bye bye.